Okay, I'm going to go ahead and get started. If you have any problems, let me know. Thanks, Nancy. I see your note there. Thank you very much. All right. So my name is Ann Bittinger. I think I know most of you on the line. Oh, let me see if I can hit that mute the audience line. If you have your own mute, that's always helpful. But let me see what I can do. I'm getting a little bit of feedback here. Hold on one second for me. All right, great. Again, my name is Ann Bittinger. Thanks for joining us for our September webinar version of Uh-oh, Are We Getting Divorced? This is the latest in our monthly webinars in which we provide education and feedback to clients about some of the things that we get calls on a frequent basis. We try and mix them up every now and then, but we really do try and make them relevant to what we're doing here at the practice. We came up with the name for the Uh-oh series because we would find that clients, often physician practice administrators, would give us a call and say, uh-oh, we're having this problem. And as we saw trends with the uh-oh questions, we developed the uh-oh series. So today we're going to talk about, uh-oh, are we getting divorced? Now, I have to give the disclosure that I didn't even take family law in law school. I know very little about divorce law or family law. However, we see some themes in healthcare relationships that I think we see in the legal aspects of personal relationships. So we're going to talk today about how we as healthcare transactional attorneys work to draft documents and to craft relationships, to prepare for a divorce, for a honeymoon that lasts, and also for the new trend of conscious uncoupling. Although physicians join up and work together either in a group or in a hospital setting, thinking that the relationship may last till death do him or her part, but the reality is that that's not always the case. You'll see that the photo on the opening slide is of a ring, an engagement ring, going on a finger. One thing that kind of gave me pause when I saw that picture and why I use that opposed to others is that it almost looks like it's a woman putting a ring on a woman's finger. And I use that to say that marriage has certainly changed. Certainly the laws on marriage have changed and are under great news scrutiny currently. But the context in which physicians have relationships, in which they work, in which they are employed, their relationships with physicians, and also as partners within group have changed in the similar ways that marriages have changed in our country. We're going to spend a little bit of time today talking about some of the trends in physician employment and in physician ownership of their practices versus working for hospital systems. We are going to talk about this too in the context of individual group breakups or divorces from members of physician-owned physician groups. But I'm also going to talk about some of the trends that we're seeing in unwinds. And by unwinds, I mean there's been a great trend recently toward hospital integration and validation with physician groups. So what we're going to do is talk a little bit about some of the boomerang effects that we see, where things are going in and people are coming together, and then just like a boomerang, the client seems to come back to me and say, this hasn't worked, we need to unwind this. So I'm going to talk a little bit about breakups in the context of physician groups, but also the hospital ownership of physician practices and some of the breakups. And more interestingly, I think, are some of the conscious uncoupling trends that we're seeing in hospital-physician relationships. Now, I'm a healthcare regulatory and transactional attorney, so what I do is prepare documents to govern relationships within the healthcare industry. In this context, we often use asset purchase agreements, stock purchase agreements, and employment agreements, sometimes shareholder agreements, almost like a prenuptial agreement. I think a good, experienced transactional attorney, particularly in the healthcare industry, an experienced healthcare transactional attorney, uses these documents almost like a prenuptial agreement, trying to figure out ahead of time what key issues might be, and really having an eye to what will happen if the group breaks up. I don't know, I don't think there are great statistics in the healthcare physician industry on divorce, but as you know, the statistic for a while has been that 1 in 2 marriages will end in divorce. I think that it is at least that. Physicians do not necessarily go in out of residency or fellowship and continue to work for the same group or same hospital system for the next 40 years until they retire. I think that general statistics show that people will work for at least 4 or 5 different employers in their lifetime. So that's expecting 4 or 5 divorces, so to speak. So let's go ahead and get started now with that context in mind. All right, so here we go. If you can't hear me okay, let me know. I see that someone said there was a little bit of breakup. Trying to have the microphone right here in front of me, so let me know if there are any problems. So let's take a look by starting off here. Here we go, with a look at Hollywood. Where else do we look at marriages, right? Let's take a look at 3 different marriages. The first one is one that's somewhat notorious between Mel Gibson and Robin Moore Gibson. As you might remember, a few years ago, there was a very bad breakup there. The divorce was not pretty, and they apparently have not gotten along well post-divorce. So I'm using them, with all due respect, as a sort of a prototype for how divorce typically happens. In contrast, on the bottom left, we have a picture of one of the most famous marriages in Hollywood. Anyone? Paul Newman and Joanne Woodward. They actually celebrated their golden anniversary in 2008. So long time marriage. On the right, we have, anybody guess? Chris Martin and Gwyneth Paltrow. And it's from Gwyneth that we got news that Chris and Gwyneth's divorce was coming. She announced it on her lifestyle website, Goop, in the spring of 2014. And it was interesting. The reason why I think their breakup got such notoriety was they announced that they weren't necessarily breaking up, but they were doing a conscious uncoupling. And the idea there is that even though the romantic relationship ends, it doesn't mean that the friendship can't continue, particularly in light of the fact that they had children. And I'd like to share with you a little quote here. Let's pause for just one moment here. If you can mute your line, whoever just joined, that would really be helpful. We had a little feedback there. There we go. Thank you. Let me share with you a quote from Gwyneth. She said, "The idea is you try to do it with minimal acrimony, and you say, look, we have kids. We're always going to be a family, and let's try to find all the positives in our relationship, all the things that brought us together, the friendship." Gwyneth went on to say, "We actually have a really strong friendship, and we laugh and we have fun." So, you know, cheers, hats off to them. That's great. But the reason why I am sharing that quote is because what kind of keeps that conscious uncoupling and relationship together, and the reason why they try not to be acrimonious is because they have children. And even when there are groups that break up, when there are physician groups that depart from their hospital system, the common thread there is patience. The patient still needs care. There are often referrals and ancillary services that one party provides for the other party's patients, so on and so forth. And also the fact of the matter is that in most communities, particularly in most healthcare system communities, it's a small town. It's kind of like growing up where I grew up in my town of 250 in central Nebraska. Everybody knows everybody. You all have patients to take care of. Can we just sort of do the right thing? And so that's kind of a nice context for our next slide. Types of relationships that we in the healthcare industry are seeing now. Conscious uncoupling. Well, we're seeing a lot of twist. Let's start down with the marriage bullet. The typical marriage is basically a hospital purchases a group and employs the group. Or physicians come together, they enter into shareholders agreements, and they work together. Divorce, on the other hand, is basically the unwind of the sale. We break it up, and in the physician-hospital setting, really the only link are hospital privileges. On the other hand, with conscious uncoupling, we have the situation where there are a lot of options out there in the world right now. And a lot of these have come to be because of incentives from the federal government, from CMS. Accountable care organizations are a good example of that. Likewise, physician-hospital organizations have been around for a very long time. I know I started working on PHOs a long, long time ago, and similarly IPAs. As you can see, IPAs and PHOs are groups of physicians and or hospitals that come together to serve a common purpose, to form a community, to have a relationship, to provide services to patients. What we're seeing more and more now are the clinically integrated networks, CINs. It's always a sexy term in the healthcare lawyer's office when we get to do a CIN, but really CIN is not all that sexy. It just stands for C, clinically, I, integrated, N, network. So clinically integrated networks are now kind of a new twist, similar to an IPA or a PHO, where via contract, not via purchase, but sort of via contract, and sometimes rather loose contracts, physicians and hospitals or physicians and other providers, or sort of just physicians, but usually there's a facility involved, come together under a relationship to serve a common purpose, to treat patients. So those are the kinds of relationships that we're seeing now. Let's take a quick look at the healthcare delivery system now. Certainly everything revolves around the patient. But what we're seeing now, and have seen for about 10 years, and now seeing twists on, is this relationship between the employers and the employer health insurance, the providers, the private market, private payers, and government programs. The interplay and everything that's going on between them right now is really, really pushing a lot of the integration and unwind that we're seeing. A few facts on mergers and acquisition trends. In 2000, this is what the pie looked like in terms of where physicians practiced. As you can see, about a great majority of them were independent, and a small percentage were hospital-owned. So take a picture of that slide in your mind and contrast it with this slide in 2008, where it turned to be from about 75% to about 50-50, independent and hospital-owned. Now, you might ask why I have numbers as old as 2008. It's because that's really when we saw a lot of the fear about the what we commonly call Obamacare, about healthcare reform, what's going to happen. And we were seeing more and more physicians say, hey, we can't do this on our own. We need either to join together into bigger physician-owned groups or to join up with a hospital system and become employed. Let's take a look at newer numbers. And I'm not sure if my friend Rick is on the line, but Rick supplied these numbers to me not too long ago, so shout out to Rick. The AMA did a study that was published just in July of this year, and it talked about the percentage of physicians who owned their own practices. And you can see the fairly sharp decline from 76% in 1983 to 53% in 2012, big drop, and then 2014 numbers were just right, basically at 50%. I would like to make one observation about those numbers. There seems to be sort of a urban myth that physicians can't sort of do things on their own anymore, that they really can't be independent, and that, oh, everybody's joining up with a hospital system. The fact of the matter is that's not true. In fact, in 2014, just a slight amount over half still were sort of doing their own thing. They were single. They weren't married. There might have been some conscious uncoupling or interesting relationships with hospitals. But the fact of the matter was that they were still owned by physicians. Let's move now to the next neon green tab there. Employed by a hospital company. So those physicians who work directly for a hospital organization. The numbers there were only compared 2012 to 2014, and you see a pretty sharp increase. Now, you might say, well, why is it 32% under that middle green tab, and it's 50% up above? Where's the other percentage? Some of that is explained by the next tab, where they work directly for this facility. You can see in 2014, 7% of physicians work directly for hospitals. A couple things there. One is most physicians are employed by a subsidiary of a healthcare system, known commonly as their physician enterprise. So they might work for the hospital company, but might not be directly employed by the actual hospital facility. The other thing that's missing from this slide that the statistics are not great on are physicians who work for companies that are for-profit, that are held and owned by non-physician owners. So those might be big national corporations, they might be privately held companies, but they are owned by individuals who are not practicing physicians. And those mega hospital groups have grown in prominence over the past few years also. This study also had some interesting light to shed on multi-specialty versus single specialty practices. As you can see, there was an increase in multi-specialty practices from 22 to 25%. Not bad, not much, but not bad between 2012 and 2014. And similarly, there was a decrease in single specialty, as you might expect, of about the same percent. What this tells me is that there's consolidation within specialties to create bigger multi-specialty groups. So it's an assumption, but this would shed light on the fact that we're seeing greater consolidation within physician groups. We're seeing physicians coming together and hopefully planning some good prenuptial agreements in their shareholders agreements or LLC operating agreements as they come together. Interestingly enough, this too supports the trends that we are seeing. The same July study says that practice size from 2 to 4 doctors increased up 2% and went down from in the 5 to 10 doctor category. So let me just take a step back and explain. The arrows going up and down tell the size of the practice. So we're seeing the onesies and twosies kind of coming together to at least make threesies and foursies. The 5 to 10 doctor size, interestingly enough, had gone down. One thought that might be a takeaway from this is you're seeing sort of onesies and twosies or threesies and foursies, the smaller ones sort of maybe coming off of bigger groups now. Like I said, some of the early unwinds are now breaking up, or some of the early consolidations are now breaking apart as people are not happy. But that's interesting. It surprised me that the 5 to 10 doctor size had gone down in those 2 years. And then the 2014 numbers for the others, those are all increases. So the only size group that dropped was the 5 to 10 docs, and then all the others actually went up, some by a pretty sizable amount. So we're sort of seeing the emergence of the mega group in a way. So let's go on to our next slide, changes on the delivery slide. The takeaways, we're seeing a decline of the solo practitioner, which is probably no surprise to many of you on the call. We are seeing a greater increase in the number of hospital-employed doctors. We're seeing an increase. Now we're seeing some success on the ACO front in terms of groups coming together and saving Medicare money. So that's a good thing. We're seeing greater creativity in how all of the providers are coming together. And we're also seeing how incentives like the ACO shared savings programs, but also incentives that have been around for a little while, such as the meaningful use monies, incentives for EMR use. I mean, we found that a lot of physicians in our practice were saying we can't afford, we want to take advantage of meaningful use. We don't want to be dinged by not having good medical record systems in the future. But man, we can't afford $250,000 for an EMR system. So some of those incentives from the government actually encouraged physician consolidation over the last 10 years. Moving to the next slide, you'll see a picture of a provider. I'd like you to take a sec and just take a look. And what comes to mind? Who are you seeing here? Would it surprise you? I love this little, the rise, hold on one second, the rise of the physician extender. Sorry, having some fun with the animation here. This is actually a picture of a physician assistant. In terms of incentives from the government, we are really seeing a push from the federal government on increased access to primary care, obviously as a result of healthcare reform and more individuals having access to the healthcare system via insurance that was brought to be because of healthcare reform. We're also seeing a rise in nurse practitioners and physician assistants because of the number of baby boomers who are retiring. A lot of physicians are retiring and groups are replacing them with nurse practitioners or PAs. I'm seeing it anecdotally here and there among a lot of my physician group clients. And then also, you know, the federal emphasis on prevention. There's reimbursement now for things like chronic care management that a physician does not necessarily have to be the one doing at his or her desk or with his or her patient. And there are a lot of programs now that are emphasizing prevention in ways that the services can be provided by nurse practitioners or physician assistants. So as we're seeing the rise of physician assistants and nurse practitioners, we're seeing that impact on the relationships that physicians have with their groups and with each other. Let's take just a moment and look at private insurers. What's in and what's out? I'm sure many of you are seeing a narrowing of networks. I have a number of physician clients that have had great difficulty unwinding or going out on their own and getting credentialed. Panels are closing. The payers are making it more and more difficult to enroll. We're seeing narrower networks. It's been a couple years now, but I remember just my gasp that I was reviewing a contract for a physician group with a payer that was capitated. Capitated plans were so popular back when I first started practicing law, and you know what? Here they are again. What's old is new again. The boomerang has come back. We're seeing you know, employed physicians, ACOs. We're seeing insurers. I think there are a couple folks on the call from Central Florida, where Florida Blue has a number of employed physicians in Florida Blue offices seeing patients directly. So again, what's old is new. HMOs that are sort of owned by the payers. And then we're seeing hospitals' own plans too. Some of those are kind of fizzling out, at least here in my neck of the woods. But hospitals sponsoring their own plans out to the community, not just to employees. We're seeing more and more of those. Some fizzling, but seems like the hospital systems are trying to get into the payer market, just like the payers are trying to get into the physician market. What's out? We're not seeing the broad access that we saw 5 or so years ago. And it seems like good arm's length negotiation between the physician groups and the payers is something that's becoming more and more difficult. So the past becomes prologue. We had consolidation. We see that wheel a-turning. We're seeing more and more unwinds now, but what we're also seeing are sort of a redo with a twist. So our conscious uncoupling with the idea that we have patients in mind that we have to treat. We have a common interest in our patients, just like Gwyneth and Chris had a common interest in their children, And we're trying to redo these with a twist. So let's take a look. What are physicians looking for? In my experience as a healthcare attorney, keys to a successful courtship, whether it's by a physician group or by a hospital, of a physician include income stability and certainty. This was probably the #1 hot button issue for physicians who came into my office in the last 10 years, or excuse me, last 5 years, probably since about healthcare reform, saying, I just don't know what's going to happen. They're messing, we have Medicare changing their reimbursement, saying they're going to cut. Hopefully we have a fix with that every year. That's not going to happen. I don't know what's going to happen with healthcare reform. I just want some stability for my family and for my income. A big factor that we're seeing is work-life balance and fewer administrative challenges. I've read a lot of articles about the decrease in entrepreneurship in physician practices, that more and more physicians just really want to treat patients and go to work in their scrubs and not have to sit at a desk and do administrative work for their own practice. So that work-life balance and fewer administrative challenges seems to be a key. They want quality facilities and they want top-of-the-line technology. Those come with a cost. During the recent recession, which hopefully we've come out of in all of the areas of the country, it was hard for physician groups to get loans to buy some equipment that would have kept up with technology. So as banks tightened their loan issuing in the recession, that also was an effect on increasing consolidation. And definitely, for similar reasons, access to information technology. EMRs are necessary and they are not cheap. So this is what physicians were looking for. On the other end of the spectrum, the reasons for unwind in either a sale or in an unwind of a physician practice cycle. I'd like to step back just for a second and say I've been practicing 18 years. I know there are some attorneys on the call who have been practicing a little longer than that. And it's interesting that there is definitely a cycle to all of this. I remember a few years ago, one of my clients said, Ann, all of your physicians are selling to the hospitals. All of your clients are closing down their practices. And that was a bit of an exaggeration, but we're all doing this. Aren't you worried about how you're going to continue your practice? And interestingly enough, my practice has thrived because a lot of these relationships still continue to have issues and because they need to change. The contracts renew, different factors happen within the relationships, and we might need amendments to certain documents. But there really is a cycle to all of this. So we're seeing this sort of some of the sales that we had done of physician groups into big primary care networks or whatnot, 5 or 8 years ago are unwinding. Some physicians are leaving. Some groups of physicians are leaving. And as all of these factors are happening in the economy and in our country's population, we're seeing this cycle happen again. So big issues. The main issue often with physicians is control. They want control of where they practice, of what they do, so on and so forth. One physician group client that I'm working with that's sort of a component of a physician enterprise of a system, is frustrated because they can't get surgical schedulers. We need surgical schedulers. Why are my patients coming in and complaining about the long turnaround time to get a surgery scheduled? Why is no one answering the phone? So there's some control about these sort of pseudo, partially healthcare physician work, practice of medicine things that are kind of qualified or related to the administrative aspects. So they can't do their surgeries if they don't have enough schedulers. But you know what? They're just employees. So they can't go out and hire another surgical scheduler. That's really where I see a lot of the angst with physicians in wanting to unwind or do something different. Obviously, money is a big factor. Physician compensation is a big issue. The expenses of physicians who are employed within the enterprise or within the practice, and physician income to the practice. So those 2 bullet points talk about productivity and a big increase in tracking physician employment and compensation based on productivity. Also, Promises and expectations not delivered upon. Major issue. Physicians and hospitals have to have a certain amount of trust. As much as physicians might say that they distrust hospital administrators, there has to be something there. And just like there's an amount of trust that's there when you walk down the aisle and the ring goes on the finger, when groups come together with systems, or when physicians come together in groups, there are certain promises and expectations that, if not delivered upon, a tone is set for disappointment and distrust, and sometimes things that might be easily solved are emotional issues or trust issues that really make physicians want to break up. So with all of that in mind, this is kind of the background in the gray area of my brain when someone comes to me and says, you know, we're thinking about coming together and starting this group, or we're thinking about selling to this hospital system. I think about, well, what's going to happen? Let's talk prenup. What would happen in the worst case scenario if this didn't work out? And so we kind of like to start with, well, what would an unwind look like? And I'm going to kind of talk about an unwind. Some of this is largely in the context of a physician group merging into a hospital. But the concept is the same if it's a number of physicians coming together to work amongst themselves in a physician-owned practice. What does it mean? What will it be when we break up? Does it require a unanimous consent of all the physicians who went in to unwind it? Does it have to be a clean break where everybody leaves? So let me just give an example. Let's say that a hospital system was buying an internal medical practice that was very successful, which is why the hospital wanted to buy it up. They had their own building. They were doing their own thing very successfully, let's say. And let's say it had, 10 owners. So a decent-sized practice, but not big. What happens if a year in or 2 years in, 8 of the 10 of those physicians say, hey, we want to walk. We want our building back. We want our equipment back. We want to basically just take the sign off the front door that you put on when you bought us, and we want to do our own thing. How would we define that? Sometimes it's very difficult to do. I've done them where it's 8 of 10, for example, or where if the others decide they want to stay employed and some want to leave, what happens? And there are different ramifications with real estate and that sort of thing. You kind of have to start with some sort of concept or definition of what an unwind would mean. All right, let's get into the nitty-gritty of my prenup. 8 issues in an asset purchase agreement, APA is asset purchase agreement, to promote a happy marriage or to protect your client in a divorce. So for healthcare transactional attorneys, the asset purchase agreement is kind of the main thing that we do when a group is bought by a hospital system. This APA would probably be substituted with a shareholders agreement or an LLC operating agreement if this was a case of a number of physicians joining in together in their own physician-owned group, or one group joining another, a merger, an acquisition, so on and so forth. But to cut to the chase, there's a document that your healthcare attorney is going to draft for you in this situation. And when your healthcare attorney drafts this document for you, they're going to want to talk to you about the following issues. First, EMRs, and the remainder of my talk today is going to be getting into the details of these next bullet points. EMRs, who owns the EMR? What if they're on other EMRs? How are your patient medical records and your operating systems going to work? And then when you break up, who gets what? Payer contracts. We're going to talk about some really interesting language that I'm seeing in some payer contracts. Let me just take a step back to explain, and I'll explain this further once we get to that slide. But one point that I may have left out earlier is one of the big drivers in physician consolidation, goes without saying, is strength in numbers. The idea was that Florida Blue or other payers will pay CPT codes or physician fee schedule rates higher to a group that has more physicians. So the onesies and twosies, we're seeing 80% of Medicare allowable. in terms of what the private payers would pay them. Contrast that to mega groups that had the negotiating power with their, let's say, 50 physicians to get 150, 175, 200% of Medicare allowable. So that was really a driver. So what happened, and this is a really interesting boomerang effect, is the payers caught on to this. And what they found is that everybody was going into these big groups, and so the 50 physicians in the community, let's say, where you had maybe 25 that were in the smaller groups getting, 80% of Medicare, moved into these big groups where now the 50 physicians in the community, if they all joined up in this specialty, we're all getting paid 180%. So let me show you some things that the payers did to counteract that and protect themselves. We're going to talk about real estate. Just like I'm not a divorce attorney, I'm not a real estate attorney, but we're going to talk a little bit about leases and space and what happens to the brick and mortar of the practice. We're going to talk about non-competes. This is one, of course, largely governed by state law, but I'm going to share with you some trends I'm seeing in non-competes that specifically target my conscious uncoupling concept. We are going to talk about price. How do we determine price? And this is where your healthcare regulatory attorney's Stark and anti-kickback statute hat comes on, and you're going to hear advice about fair market value. We're also going to talk about a forced sale back, that this might be a good thing to secure for your client. We're going to talk about location control and autonomy. You remember that one of my keys to a successful courtship bullet point was control. So we're going to talk about control. And we're also going to talk about contacting patients about what's going on. That's the slide or the bullet point about who tells the kids in the divorce or who tells the patients in the physician divorce. So let's talk about the use of that document, whether it's an asset purchase agreement, an employer agreement, or whatnot, in the context of payer contracts. What we're seeing in some of the new contracts from the payers, and by that I mean the Florida Blues, the Aetnas, and Humanas in their contracts with physician groups. There is language that's going into a lot of these that says that if, in the event you merge with a bigger group, the rate that you agreed to pursuant to this contract for reimbursement for services is the rate that you will keep as an individual provider for the next 10 years. So this is the payer trying to say, we can't survive if all you guys that were paying 80% of Medicare merge into a group and try to get under a contract where we're paying 200% of Medicare. Now, I have to tell you that as an attorney, I would love to see this challenged. I would love to challenge this because, the individual providers go under a different group contract, and I'm not sure that it can be upheld. But oftentimes, and forgive me if I sound a little jaded, but my experience in representing physicians is sometimes the payers do what they can that might push the ticket on the loss, shall we say, and see if a physician group has the moxie to sue them, to challenge them. So what happens is if a physician group or an individual physician had signed like a joinder agreement where an individual physician might actually sign a sort of an attachment to their group's contract with the payer, if that physician goes and joins mega group, the payer will simply line item and pay that physician's work within mega group at the 80% of Medicare rate, for example, that he was paid under the other group's contract. Again, I'm not sure that this is a legal thing, would love to see it challenged, but they're just doing it and saying, you don't like it, sue me, basically. So be very mindful. Attorneys who are on the call or contract administrators, if you're thinking of a merger, in the due diligence process, you have got to look for this kind of language in your client's contracts. You're not just looking at rates. You're not just looking at general contract provisions, how long is your contract with Florida Blue, what's your payer mix, that sort of thing. You need to find if there's this kind of language, because you can imagine if you have a physician group that relies on selling their practice to mega group, thinking that their main reason for doing this is that their reimbursement's going to go up by 40%, and then 5 months in, they do an audit and see, you know what, we're at the same reimbursement amount that we were. You're not going to have a happy client, and they might blame you, attorney or consultant or advisor, for not pointing that out to them. So be very careful on that. I'd like to turn now to EMRs. In the breakup process, there is probably no aspect that's more difficult operationally than the patient's medical record. And a lot of this goes to the technology of EMRs. My second bullet point here on this screen is software and interoperability. So what happens if physician group A is on Allscripts and they sell to physician group B, which is on ABC, healthcare EMR? How do we transition those records in? How do we make the systems interoperable? How do we make it usable going forward? Similarly, what happens on the breakup? What do we do if we had old paper records going in? And then if you know anything about divorce law or about family law, there's a concept of marital property. And again, I passed a few bar exams, but I did not take family law ever. But the idea, simply put, on marital property is what is earned and what assets are gained to the members of the relationship when married are marital property and need to be treated as such. However, what the individuals in the relationship bring in, what they had prior to the relationship, is treated differently. So consider that concept and apply it to healthcare records. So we have folks bringing something in. Then, of course, the patient's going to be continued to be treated. So then we have that sort of marital property record. And then what happens when it breaks up? It's almost like we have three different silos analytically to consider. The premarital property versus the record creating during marriage. The key to this, the real key, if you want to try and provide a solution and sort of cut to the chase with your practice or with your client, is there a way for the post-relationship transaction to use the same EMR or to at least have some sort of an exchange or purchase a license, extend the license, revise the license agreement for the EMR system and license that was at the existing practice? That's really the best way to do it, because my experience is that these systems don't talk to each other, and it's very, very difficult to work from two systems going forward for a number of years until you can get information in, or until, you know, in some practices, the patient issues resolved. But in family practice or internal medicine, pediatrics, the patients are going to be yours for a very long time. So it's very difficult if you can't figure out a way to get the records over to the new group or to those who leave. HIPAA obligations post-divorce. This is an interesting situation because it puts the patients in the position of having some power over the relationship between the group and the departed members of the group. What happens if the physician receives a request for medical records? The physician has to send those records, and by send that means a lot of different things in HIPAA 2015. But if a patient asks for records, the general rule is the physician has to provide those to his ex-partner, or the system has to provide those to the departed doctor if the patient says that they need to, within 30 days, or at least they have to respond within 30 days and get them to the patient within 60 days. If anything, the group that has the records has to do something in 30 days. And so what sometimes happens if you cannot work out a cordial parting of the medical records and health information is that patients become a pawn. Patients have the power, and patients submit HIPAA authorizations for the records. And at that point in time, the practice has to provide those to the departed or to those who have unwound and left the group. It creates a very tense and difficult situation at times. So if we could put in an asset purchase agreement going in that group will take every effort, for example, to coordinate the exchange of health information via an amendment to its license agreement with the EMR company should any physician leave and terminate their participation under this operating agreement. Something like that. So while you can't guarantee that all scripts or whomever will grant a license to the new guy, chances are they will. And typically the transfers are done, in my experience, by some of these big companies at no charge. So sometimes it works out extremely easily. Sometimes it gets to the point of a patient is at a physician's office and there's no medical record even though it was requested more than 30 days earlier. So very, very difficult situation at times because it goes to patient care. Let me just touch quickly on my last bullet point here, survival. So for those of you who are fluent in contract law, an asset purchase agreement is kind of like a, it's a purchase agreement. So once the purchase is done, usually the contract sort of goes away. It's almost like a receipt. Okay, we did what we were supposed to. We sold what we were supposed to. It's done. We need to, when drafting these agreements, make specifically clear that these sort of what happens after, these sort of prenuptial sort of twists on these documents survive. So we have to say that this contract will terminate, upon acquisition of XYZ practice. However, sections 4, 5, and 6 survive that event and will continue on until blah, blah, blah. All right, let's go on to the brick and mortar part of the talk, real estate. What happens if a group is acquired and stays in the same place? So let's use my internal medicine practice example. And so basically what happens is usually the physician group owns the building. Probably the individual physicians own it in a subsidiary or a separate company that's just a separate real estate company from their physician practice company. And instead of leasing it to their physician practice company, they now lease it to hospital, physician, enterprise, or health system real estate services group, something like that. So really same lease, it's just to a different entity. One thing to keep in mind is what happens if this merger doesn't work? What happens to the real estate? So as drafters, the attorneys have to make sure that they link lease entry with the acquisition entry and link the divorce if there's a breakup, that the lease ends if the employment of A, B, and C physicians ends. So basically you don't want to have the situation if you're representing the physician group that's merging into the practice or similarly merging into a mega group. You don't want that mega group to hold the lease of the space of the building that the physicians own when the physicians might no longer be employed by that mega group or system to perform services. So you don't want the former employer holding the real estate hostage. So make sure that link is there. And again, it must survive. Now, this becomes very dicey in just a physician group breakup, a physician group owned by physicians breakup, because what you're looking at are typically operating agreements or shareholder agreements that talk about, or perhaps don't talk about, what happens if a physician leaves the group and is no longer employed by the physician company, but is still an owner of the physician's real estate company. Sometimes it kind of depends on who you're representing in the situation. But if you're a group and you bought another group or a little practice somewhere and it doesn't work out, do you still want to be obligated to be the landlord or the tenant, vice versa? You get the situation. So definitely need to keep what happens upon a breakup, real estate issues in mind as these things are coming together. Moving on to non-competes. The issue here that I find is very interesting is this question. Are patients who are brought into the system or into the mega group in the acquisition, are they considered like premarital property? Like what if I had patients that I brought into a group and I merged into this big group? and they were my pre-existing patients. Is it really right that when I leave that I cannot treat the patients that were mine even before I went in? And what's interesting is I think that most non-compete provisions are written such that the answer would be no, it doesn't matter. You can't continue to treat those patients because you treated them when they were with us. But sort of the ethical standpoint is it's interesting that that would be the case. So what we're doing is drafting exceptions to non-competes that might say, provided, however, the physician can continue to treat any patient that was a pre-existing patient as of date of acquisition or date of merger. So that's an interesting exception that we're putting in. In the health system and physician context, I was shocked. I remember, again, a few years ago, the first time I saw this kind of a non-compete. What it was is the hospital system said, you know, you have a 2-year, 20-mile non-compete. However, it only applies if you go to work for one of our competitors. And that was kind of an aha moment for me to say, gosh, acquisitions have become so big and so many physicians are being employed by health systems now that what happens is this conscious uncoupling and this caring about the patient. So let's say you go merge into big hospital system and you decide to leave. Well, hospital system still wants your referrals, right? So if they want you in 2015 to stay in that medical office building on the hospital campus and continue to treat patients there and refer all your ancillary services, all your diagnostic testing, and to admit patients to do your surgeries, to deliver your babies in that hospital system. So it's interesting that non-competes are actually crafted in a way for some of these hospital systems that actually helps to secure the physician to stay in the same space. It doesn't specifically secure them, but it says basically you can't operate anywhere else in the area if you're going to be employed by somebody else who's a competitor. And that's kind of encouraged physicians to unwind but remain independent. So very, very interesting dynamic there. You'll see that I've tied in this slide with the real estate slide with my last bullet point, which talks about the location issue. The non-compete is very interesting if the brick and mortar building where the physician is employed is actually owned by that physician. So you can kind of connect the dots mentally in your mind on that. If basically two physicians groups merged, or if a physician group went into a hospital group and still stayed physically in the same building that they were in prior to the merger, what happens upon a breakup if there's a typical, 2-year, 10-mile, hopefully not a 10-year, 2-year, 10-mile non-compete, and the physician actually owns that building. So we touched on that earlier. Again, it's where real estate and non-competes collide. Let's move on to the highly complicated area of price. The concept here is what goes in must come out at a reasonably related price. So here's the situation. I have a client come in. I had helped him sell his practice. Let's say he got $2 million for the sale of his practice 5 years ago. And he comes back and he wants to buy back the assets of the practice, but he only wants to pay $250,000. The idea is that the price that the practice was sold for, it kind of needs to be bought back at about that same price, unless there's a huge increase or decrease in the productivity of that so-called practice, whether it's an enterprise or a line item in a big system. But the idea is if it's not, then what are you paying for? The idea is that in these sorts of relationships, we often have referrals. This is more applicable in the physician group and hospital merger than physician group and physician group merger. But it could apply in those situations too, certainly. The idea is, how do I defend a lower buyback price than an extraordinarily bigger price that the physician was paid to sell. It looks then like that difference, that cushion in between those two numbers, was a payment for the physician's referrals. And I have a quote here from one of the more famous cases that's currently worked its way through the system. And it's this. It says, it stands to reason that if a hospital provides fixed compensation to a physician that is not solely based on the value of the services to the physician is expected to perform, but if it takes into account additional revenue the hospital anticipates will result from the physician referrals, then that compensation by necessity takes into account the volume or value of referrals. Now, volume and value of referrals is kind of a mantra of health care lawyers. It's our mantra. We say it over and over. We cannot take into account in valuations the volume or value of referrals. It's a violation of the anti-kickback statute, and it certainly implicates some stark issues typically. It's interesting where you might want to make an argument for a bigger price if you're selling than if you're buying, or vice versa, depending on who you're representing. But we could talk for hours just about this slide. The takeaway is, generally speaking, the price that you sell for has to be similar to the price that you get out for. Let's move to the forced sale back. In the event of an unwind, then what this kind of provision would require is that the hospital must sell the equipment back to the physician group. And it might not be just equipment, it might be licenses, it might be a bunch of stuff. Again, the asset purchase agreement must have this provision survive. But the idea of this comes from this, in my experience. The hospital administrator, or the strategic planning guy in the health system who's going out and trying to buy up all these physician practices in the community, says, you know what, we're easy in, easy out. It'll be easy for you to come in. We're not going to put up a bunch of walls. And you know what, if you don't like it, we need to be friends. We'll do a little conscious uncoupling. We'll get along after. It'll be easy for you to get out. Okay, so then the client comes to me and says, hospital administrator said it's easy for me to get in and easy for me to get out. And that's when I say, oh yeah, where does it say it's easy for you to get out? And then we craft some provisions like this. This would typically apply in a situation like that internal medicine practice that I talked to you about. So they had their own brick and mortar building, they were a defined group. They basically want to take that sticky decal on the front of their door that was the hospital system's logo on it when they sold, and they basically just want to sort of peel that off again. Now, we know it's much more complicated than that, especially in the world of payer contracts and Medicare enrollment and whatnot, but that's basically what they want. They want all their equipment back. They want their staff back. They want to just kind of continue to operate. So how you craft this depends on the facts and circumstances of each client. However, having this concept in mind that you get something back when you leave and that you have to give it back is one that really we all need to take a look at. So let's move on to location control and autonomy. Like I had said, control is a big issue. And my internal medical practice, again, is another good example here. If a group merges in, whether it's to a medical group or a big hospital system, and they were kind of a defined, healthy group, they want to keep doing what they were doing. They want to have local control. So what I try to do is, and it might seem a little tedious and a little atypical for an asset purchase agreement or an operating agreement, but I try to carve out decisions that can be done at this level. This is to address the idea that physicians will just be employees. They are not owners of the company that they work for anymore, so their hands are tied in terms of hiring employees, firing employees, that sort of thing. And then I try to make maybe one of the physicians or an administrator a, quote, location chief who has the ability to make decisions about that brick and mortar building, about the people in it. They might get a credit card for the site's administrator that they could spend no more than $200 on. You know, I had an administrator once say, if I want to have a holiday party and celebrate someone's birthday and I want to go get a cake, I know the hospital system's not going to let me go get a cake. And believe it or not, that's very important to the operation of a physician practice. Apparently cake is very important. I had someone else say, if they come in and want to change the decor that we just work so hard on, they are not taking down these pictures and they are not changing the carpet without my say. And I say, do you really want me to put that in the contract? I'm happy to, with a big smile on my face. And a couple times I've done things that were that specific. But from the hospital standpoint, you know, what do they care typically? They just want the group to continue to be the successful group that they courted and married. So sometimes giving on those sorts of things works in a charming sort of way. Finally, contacting patients. It is nice when you go in, if you decided ahead of time what you're going to say to the patients when you break up. If you're a group that's merging, if you're a physician who's attorney who's representing a group that's merging, if you are worried, if you're a bit wary as your client is walking down the aisle, a good thing, one of the main things, is to be able to keep a phone number or a website domain if they leave. Again, you know, for the longest time, I never would have put a provision like that in a purchase agreement or in an operating agreement. But the ability to unwind and keep your patients is largely dependent on their ability to reach you, which means you get to keep your own phone number. So that's kind of an outside of the box but very interesting operational / legal provision to put into an agreement. And with that, we are quickly approaching 1 o'clock. I'm going to unmute the lines and just wait a few minutes. If anybody has a question, they can chime in, or there's the communication box at the end. All right. With that, my email address is there on the slide. We want to thank you for joining this monthly Uh-Oh. Next month, we are going to be tackling the hot topic of drug diversion with physician practices, tampering, and what happens when the DEA agent shows up at your door. So if that interests you, I look forward to speaking with you and hearing from you next time. Thank you very much.